So I think we can go ahead and get started. Good afternoon. Welcome everyone to this virtual town hall put on by the Knoxville Bar Association. I'm Hanson Tipton, president of the Knoxville Bar Association. I want to wish you all a happy Law Day, and I'd like to thank the Honorable Sharon Lee for joining us today. I want to let everyone know that we are recording this conversation, and so if you have any technical issues or have to leave for some reason, it will be available to watch later on after we're done today. And I do have some questions that people emailed me to talk to Justice Lee about. But if you think of anything or we're not able to send in a question, there is a Q&A box on the very bottom of your Zoom window. It's just to the right of the participants button. And if you hit Q&A, it'll allow you to ask a question, and we will try to keep an eye on that and ask any questions that we see there. There's also a chat bar window, and I know in the past when we've had these events, people have used that to just add comments, or if they might know the answer to a question that Justice Lee doesn't know, people will sometimes put that there. So we'll try to keep an eye on those windows. I want to remind everyone that it is Law Day, and we originally planned to be together in person with Justice Lee, among others. And we have rescheduled the Law Day luncheon for August 19th and plan to have the same speakers speaking on the same topic, which is the 19th Amendment at 100. Cheryl Rice will be moderating, and we will have Justice Lee, Sharm Allen, Becky Duncan Massey, Wanda Sobieski, and Joycelyn Stevenson speaking on that panel. So I look forward to that. You can register for that event and also any other events that are coming up in the future at knoxbar.org. And if you have any issues with that, just let me or Marshall Watson know. Justice Lee, thank you for joining us today. A little bit of brief information about Justice Lee. She was appointed to the Tennessee Supreme Court in 2008. Was retained in retention elections in 2010 and 2014. Prior to her service on the Tennessee Supreme Court, she served on the Court of Appeals from 2004 to 2008, and she was the first woman to serve on the eastern section of that court in its 79-year history. And so Justice Lee is a very appropriate person to have on our panel for the 19th Amendment at 100. Justice Lee served as Chief Justice of the Tennessee Supreme Court from 2014 to 2016. She has won numerous awards for her professional achievements and community involvement. This afternoon, we appreciate you joining us, Justice Lee. Thank you for being here.
Thank you. And I want to thank you and Marsha and the KBA staff for doing a good pivot away from the Law Day luncheon that we all thought we'd be attending today about the 19th Amendment and scheduling this meeting because we're going to discuss the court's response to the COVID-19 pandemic, and I think it's a very, very timely topic. The 19th Amendment will be very timely in August, and that actually is a more appropriate month to celebrate the 19th Amendment. So this has worked out well, and I appreciate KBA's being so sensitive to the needs of the bar in this regard.
Well, thank you for adjusting with us. I was hoping to see you today on the dais at the luncheon, but the old saying goes, people make plans and God laughs. So we will we'll adjust our plans for and get together in August. Justice Lee, would you like to maybe start off by giving us a summary of the Supreme Court's orders that have been entered as a response to the COVID-19 pandemic?
I'll be glad to. And I have a whole stack of orders that I knew we had issued a number of orders, but when I got them all printed out here this morning, I was really surprised at how many we've actually entered. And that's because there's no game plan for this, and we've never encountered this. And Tennessee was one of the earliest states to suspend in-person hearings. So when we were drafting this initial order, we really didn't have anything to go on. We looked at an order out of Kentucky, but it didn't really meet our needs. So we were really making this up as we went. These orders are all posted on our 10courts.gov website. So at any time you're not sure about what the court's orders are, go to 10courts.gov. There's a special banner for COVID-19 orders, as well as all the judicial district plans. They're all posted on there that have been approved, and we'll talk about that a little bit later. But on Friday the 13th, a very appropriate date, we got together and decided we needed to get an order issued. We realized things were really taking a bad turn, and we needed to protect the bar, litigants, and judges from COVID-19. So we, as I said, Friday the 13th, we filed our first order, which declared a judicial state of emergency. And we suspended, first the order, it's very important, it says that courts are open. We're not shutting down the judicial system. We want to make that very clear. But we did suspend all in-person hearings in all state and local courts through March 31st. And the reason for that relatively short date was we didn't really know how this was going to go. And we thought it probably would end up being, we're pretty certain it's going to be end up longer. We knew we'd have to tweak this order and change it as we went. So we did it till March 31, but we were very careful not to suspend everything. But we left in place exceptions to the suspension, which included protecting defendants, criminal defendants' constitutional rights, particularly related to bond hearings, entry of pleas for incarcerated individuals. We knew March 13th that we really wanted to start reducing jail population. We didn't want people sitting in jail without bond, or people who wanted to enter a plea with no recourse. So we kept that open. Jury trials were suspended. That was really a no-brainer. We allowed judges to hear order protection, child custody, emergency child custody orders, petitions for temporary injunctions, all sorts of emergency type matters the courts were able to handle. We encouraged electronic hearings. We encouraged judges to do things, to take care of business without having people in court through electronic means. And we said, if you do have in-court proceedings, only allow the attorneys, parties, witnesses, security officers, and absolutely necessary people to be there. We reminded judges in the order that you're charged with the responsibility of making sure that core constitutional functions were protected, and encouraged the use of technology. We wanted to make sure that clerks' offices did not shut down, that they would remain, if they had to physically close, but they did have to remain accessible by telephone, email, fax, that's kind of a throwback, and then installed drop boxes. We extended deadlines. There was a concern that if you had a statute of limitations running or some deadline, and you couldn't get there to get it filed. So we extended that through April 6th, which was beyond the period of the order, but we wanted to give people time to kind of get on their feet and get their stuff filed through April the 6th. And that applied to all deadlines and everywhere. Orders of protection were extended through April the 6th. And then we came along on that same date, and March 31 was the deadline for people to complete CLE for 2019. So we suspended at that point the requirement they had to have 8 hours, no more than 8 hours of distance learning. So we suspended that so that people between March 13th and March 31 could finish their CLE for 2019 by going online to do that. Then on March 25th, we came along, and in anticipation that this order would expire on the 31st, we did a new order extending essentially that first order through April 30th. There was some additional provision where we ordered each judicial district to come up with a written plan to reduce jail populations. Really, really concerned that COVID-19 would get in our jail populations, and that would be a very serious matter. But we were very sensitive to that. So we said, all right, everybody, look at what you got in each district, come up with a plan to reduce and get those filed. Actually a very short deadline. We said you had to have them in by Monday, March 30th. Everybody did that. We have seen really a good judges, DAs, everybody worked together to do a significant reduction in jail populations. I think statewide, the as of the last time I checked, it was down 30% statewide. In some districts, I've seen some districts that are down like 75, 80, 78% reductions. I read yesterday, Knox County, I don't remember the percentage Knox County is down, but they're well under. They have reduced significantly. There's not been any COVID-19 problems in the Knox County Jail. And I don't think we've really, there was one district over beyond Nashville that had some jail personnel who tested positive. But I don't think it got in the jail. I don't think we've had a problem. I think the state prisons have, we're seeing Bledsoe County and some other prisons have had some pretty significant outbreaks. I don't think we've had that problem in the county jails that I'm aware of. But this has been a really good situation. And there was some concern initially, you know, you're going to turn the jails out and get all these criminals on the streets. But people who were released were essentially nonviolent offenders, people too poor to make bond. It was just the right thing to do. So I think that had a very good effect. We also, in this order, said, you know, you can use the Online Notary Public Act, and you can file, you don't have to have things notarized, you can use the penalty. Just reminded people that you could file the declaration under penalty of perjury as set forth in the rules, so you didn't have to have a notary there. We also said you can't evict people. That was an important part of this order. We stopped evictions. That did not stop foreclosures, which ultimately can result in an eviction, but it stopped evictions. And that's something that's been going on nationally, but we thought that was important. Orders of protection were also extended through May 6th. And then we came along on March 27th and removed the 8-hour limit on distance learning for 2020. So this year, everybody can get their CLE all online if they wish. And I think that's positive. And that may be something we want to continue. I think initially when we put the 8-hour limit on distance learning, it was thought, well, it would be abused or it wouldn't be as effective and that kind of thing. But I've never seen a problem. I've never seen a problem with distance learning. So for 2020, you can get all your hours through KBA online. Marsha, I know you're going to want to hear that. So we'll see how long that lasts. Hopefully that may go forward. So then we came along March 27th, and if you're facing a BPR disciplinary hearing, the restrictions applied to that as well. So people facing those hearings got a break. Also, the deadline for paying the fees got extended through April 30th. And then we came along March 27th and trying to help appointed counsel, indigent defense counsel, and said if you're filing a claim up to $400, you don't have to go through the judicial review. You can submit those directly to the AOC. It raised that from $200 to $400. So then we also instructed all judges to make sure there were no pending claims for approval sitting in their inboxes. And judges approved an extraordinary number of claims during that time. A huge number of claims got approved by calling everybody's attention to that. And then a large number got sent on straight through to the system, up to $400. So that didn't solve everybody's problems, but it had to help some. And also, this order doesn't say this, but of course, if you're almost to your limit and you don't see a court hearing coming, you could also go ahead and submit your time for the entire case. Or if you've maxed out, but still a case is still pending, you go ahead and file that. So then that brought us to the end of March, and we realized we had stopped all deadlines from running, which included their briefing schedules for in our appellate rules, and yet we had cases docketed, and we plan to continue those dockets. So we said, oh, by the way, the extension through May 6th doesn't apply to deadlines in the rules of appellate procedure. You still got to get your briefs written. And that really only applied, it didn't apply to too many cases, but we had some cases on the docket in, I guess, the May docket that briefing needed to continue. Let's see. And of course, honestly, judges are going to be very lenient in granting extensions for the briefing deadlines. Then we got to April 2nd. This is perhaps my favorite order, April 2nd. We said that the court extends the use of electronic signatures. You can do an electronic signature on an e-file document, but like Knox County doesn't have e-filing. Right. So we said you can use e-signatures on pleadings now, as you could if you were e-filing. And this came up, why this is my favorite order. And I don't know if Culver Smith is on the call today, but Culver called me or emailed me that morning of April 2nd and said, hey, we're having trouble. I mean, he said it more formally than this, but essentially, we're having trouble. Lawyers are working remotely. They're having trouble getting into the office to do the signatures on pleadings. Could we get permission to do, if y'all thought about doing electronic signatures? And the answer was, well, no, but why wouldn't we? So, but of course, in the back of my mind, I'm thinking, a change in a court rule like this is going to take, it's going to take some time. And I'm sure he thought it would too. So I sent an email to the court saying, hey, got this inquiry. I think we really need to allow e-signatures on pleadings. And the court said, yeah, right, we should. I sent it right then to a staff attorney to draw this order. And that afternoon, we had an order allowing electronic signatures. So I was very impressed that we were able to do it so quickly. I take no credit for it, but it was pretty cool the way that worked. And I emailed Culver that afternoon and said, at your service, your request is being granted. And then I also did the extra step. I'm the liaison to the Rules Commission. So I actually sent this to the Rules Commission to say, let's consider allowing e-signatures going forward on all pleadings. I don't understand why we don't do that, frankly. But this would be a good change in the rules to allow electronic signatures. So we'll see where that goes. It may or may not get approved as a permanent rule change, but I hope it does. So that was one of those issues that I was not aware of was a problem. Maybe if I thought it through, I could have figured it out, but I was really glad that Culver brought that to my attention and we were able to respond. So hopefully that's helped some people. The bar exam, probably none of you are facing a bar exam. You've already been through that pain, but we have, the July bar exam was in limbo. And so we did an order about that. And then ultimately we now have a July bar exam scheduled and we have a September bar exam scheduled. It's called the September option, I think. And it is, that's the date here, but I can't find my paper. I think it's like the end of September. It's a 2-day bar exam. Interestingly, it's going to be done in Knoxville, only in Knoxville for the entire state, because that's where we were able to get a venue big enough to accommodate everybody at a price that was within reason. So the September option bar exam will be done in Knoxville. And I don't know how the deadline for applying is, I think, May 5th. So I don't know how the bar signups are going. I don't know. I would think if it were me, I'd probably want that little extra study time. So I'd probably choose the September day just to put it off. But so I don't know. I don't know how people are thinking about that. So then we came along April 24th and said, okay, this thing is still going on. So we're going to continue with our order, suspending hearings. Jury trials are suspended through July 3rd. You don't want 12 people in a little jury room. There's just no way to keep the jury 6 feet apart. And that's reason.
Or a pool of potential jurors.
A room of potential jurors. And that was the reason for the bar exam dividing it up as well, is that they got to be 6 feet apart. And then there's so much anxiety about, am I going to go in and do the bar? The bar is bad enough. What am I going to catch? So yeah, jury trials. Although when we first started early on talking about suspending the first order jury trials, my thought was, yeah, jury trials are bad, but have you ever walked into Sessions Court and see this massive humanity packed in on those benches for hours at a time, that's where it's going to spread. Jury trials, that's not good, but sessions, municipal courts, that's where you have lots of people packed in. So it's got a lot of states just sort of focused on jury trials, but I never thought that was the big problem area. But anyway, they are suspended through Friday, July 3rd. We still encourage courts to conduct as much business as possible other than in-person hearings. So in other words, please just continue to do electronic hearings. Please don't bring a lot of people in the courtroom. And everybody's going to continue under the March 25th order until we have your plan approved. So what we ordered the presiding judge of each district was to present a plan for how each district is going to handle their cases. And thought behind that was every district is different. You know, right now, say in Shelby County, there's a lot of COVID-19 going on. They've got some really bad numbers. You know, Monroe County, where I live, it's not so bad. So in the 10th Judicial District, for example, pretty low number. So each district's different, and each district ought to have the autonomy to figure out what's best for their district. So that's why we put it to the judges to come up with a plan for each district, and there are certain parameters. You know, you got to address the limited, you know, how you're going to stagger admission into the courtroom, staggering hearing times, management of social distancing in the courtroom, how you're going to handle witnesses, encourage use of face masks, disinfectants. We clarified that you can ask people, you know, are you sick, you having a fever, know anybody with COVID-19, and you can also take their temperature. So right now, the difficult part of this was the presiding judge of each district has to get every court in that district with a plan. In other words, Knox County, Judge McMillan, the presiding judge, gets his court, gets all the chancery, gets the criminal, gets circuit, and then gets every city court in Knox County and general session. So there's a whole lot of judges involved, different courtrooms. So those plans started coming in. The plans in the first and third, Upper East Tennessee, first and third districts have been approved. Right. And 14, 16, 17, and 19 in Middle Tennessee have been approved. These are all on our 10courts.gov website as well. Okay. You can click on to see the plans that have been approved and see what the plans are. And there are several more pending plans. Knox County, the 6th Judicial District, submitted its plan on Wednesday. I talked to Judge McMillan actually before we entered this order to say, I'm just giving you a heads up. We're going to enter this order tomorrow. We're going to want a plan. I know you want to get back in business, and he had already started on a plan in anticipation of what we were going to do. So I know he's worked very hard on getting all the judges in the district together to figure out this plan. It was submitted Wednesday, and I'm really thinking it may get approved today. At least I'm hoping that, because they're really trying to do a pretty quick turnaround on these plans. So I'm keeping my fingers crossed we get word back today that was approved. If not, most likely Monday. But until that gets approved, we're still under this old order. And then that other deadline just clarified that the deadlines for all the suspension of all the deadlines does not apply to pretrial scheduling orders. So if the judge has said, get all your discovery done by April 30th, that still stands. So there was some question about that. Actually, there was some wrong information on the website. So we got that fixed. And that was also brought to me by an attorney. We got that fixed, but if the judge has issued a pretrial order, you got to go by and not go by this order. The eviction prohibition still stands, and this order then, orders of protection lasts through June 5th. So the BPR then came along later and did further suspension of their proceedings through May 31. So that's where we stand. So we're just in the process of getting each judicial district on board with their plans, and see where we go from there. I suspect that I don't think we're going to wake up at the end of this month or say May 31 and this thing's gone away. I think it's going to still be here. I worry that opening up the state, opening up businesses, where I know it's really necessary for the economy, but I worry there's going to be an increase in cases. So we're really just taking it, a day at a time and keeping an eye on it to see what needs to be done. So that's where we are right now. I'm happy to answer any questions.
All right. Well, that was a lot of information.
I didn't mean to take so long, but after I started going through this, I'm like, there's been a lot of orders here.
There have been, and that was a lot of information, and you covered some of the things that people have wanted me to ask you about, and so I'll try not to repeat too much. But
okay.
But I personally was just curious with you, Justice Lee, how has the pandemic changed life for the court in its day-to-day life, and how has it changed life for you?
Well, I'll say it hasn't changed it that much because the life of an appellate court judge is particularly suited to a quarantine. We're just in a quarantine anyway. So it has given me more time to work on cases. Our court work has actually not stopped, and we've actually had extra work working on these orders and monitoring the situation. We have continued to have our business conferences and by video. We do those by video anyway. Do those to approve applications, to review the applications, permission to appeal, to grant petitions, to deny petitions. We've met to approve opinion releases. We filed, I think, 3 opinions this week, maybe. I mean, our work has really gone on. I think I filed 2 opinions during this quarantine. So we're really up to date on our work because the particularly CLE presentations and receptions and luncheons and all that stuff have been canceled. So it's really allowed me to focus on the casework, which I particularly enjoy. We did cancel we had a docket scheduled in April for Jackson, and we did that. I think we had 4 cases, 3 went out on briefs. The lawyer said would have submitted on briefs. 1 wanted argument. We did that electronically, and it was fine. It was very, very good. It did save me about 10 hours in the car driving to Jackson and back and spending the night. So what would have been essentially 2 days out of the office turned into an hour of oral argument in my office. So other than just, being afraid you're going to get a disease and die, it's actually not been that bad. I mean, other than the inconveniences everybody's suffering. But the court's work has really gone on. We have not stopped doing our work. We did have a docket. We have a docket scheduled in Knoxville. I think it's May 17th. We're going to do that electronically. We had Boys State scheduled in Cookeville and Girls State in Nashville in May, and those are always really fun dockets. Those were all canceled, but we're hearing those cases, and then we're having a docket in Nashville. So we're hearing a whole bunch of cases at the end of May by video conference. Probably 10, I'm guessing 10 or 12 cases by video in May. So we're continuing to do the work just a little bit differently.
And that's a good segue into the next question I wanted to talk to you about. And obviously our as a legal community, as well as just as a community at large, our collective experience during this pandemic is going to change the way that we all work moving forward. And the question is, how will it do that? And you touched earlier on hoping that maybe electronic signatures on pleadings will continue to be allowed even after we're all back to whatever the new normal is. But how do you envision the work of courts and lawyers will change? Will the use of remote hearings continue? Will the implementation of electronic filing accelerate? Will video depositions become the norm? What sorts of changes do you think that we may see that are permanent that come out of this?
Yeah, I think we've learned a lesson from this that, I think we've seen the importance of e-filing, just the need to have e-filing. I think we've all kind of known that, but We've seen those districts with e-filing that have been able to continue on, and those who don't have e-filing, it's been problematic. I'm not convinced that the world's going to return to normal anytime soon. So I think we're going to continue to be in somewhat pandemic mode for the next year or so. So I don't think we can ever replace in-person hearings. That's something that's very valuable. But I think judges are now educated on using Zoom and electronic hearings, and they're seeing how it's very effective at times. So I think we're going to continue some with that because we've already kind of gone up the learning curve. I'm hoping this moves us faster into everybody adopting e-filing. I think we've learned some good lessons. I think, for example, if we get the electronic signature on pleadings adopted, that's a good outcome. So I think there's going to be some benefits and some continuation of what we're doing now in the future. But I mean, we've got to get back to having jury trials, you know, as soon as we can in July, for example. The courts have to get back. We, for example, have canceled our judicial conference in June because, one, you don't need to get all the judges in the state in one place, and two, they need to be working. With this, when these restrictions are lifted, there's a big backlog, and judges need to be working. So it's going to be interesting to see how this changes. I think we're going to benefit in the long run from it.
And Justice Lee, when we talk about things like electronic hearings and what we're doing here today, right now, talking over the internet, I know we spoke earlier this week, and you mentioned that this crisis has highlighted the issue of inequality of internet access across the state. Has the court considered that in its decision-making process, and if so, how? And what are some ways that we can deal with internet inequality?
I think the inequality really is a statewide issue that I know the governor's office has looked. I know Governor Haslam looked at it. I think Governor Lee is focusing on it. It's just an infrastructure issue. But I know when we were talking about allowing hearings electronically, I had a concern that if I were still practicing in Madisonville, I probably wouldn't have the bandwidth there to do electronic hearings. So I've emphasized that we have to be very, very sensitive to lawyers' ability to connect and have sufficient bandwidth to do an electronic hearing. And if not, then, and there was some discussion, well, that the lawyers who don't have the bandwidth can call in. I'm like, no, I mean, if my opponent's on video, I'm going to be on video. We've not seen a problem with that yet. I know in Nashville with the tornado, they had some lawyers in the AG's office who were having trouble working from home with difficulties with internet. So it has affected. I think one thing that I've been concerned about was the inequality of internet service, because when I have to do anything, I can't do it from my home. I have to do it from the office because it's not reliable. But my concern has also been lawyers with families and children out of school, daycare's closed. What do you do when you're a single parent or even both parents working? What do you do with your kids when you're supposed to be in court? So I think we have to be very sensitive. I think all judges have to be very sensitive to the particular difficulties that this pandemic is placing on people in terms of child care for one and internet service on the other.
When we talk about the ways that judges and lawyers are adjusting to this, including technology and remote hearings and that sort of thing, do you anticipate any procedural or evidentiary rules moving forward to address remote proceedings, whether it be depositions, hearings, or trials, or what have you?
It's possible. The orders we have suspended all rules that prohibit electronic means of having hearings or any proceedings. So those rules are suspended at this point. If we see the need, I think that will continue to be suspended. And there may be some other matters to come before Rules Commission on suspending or changing our rules to be more accessible remotely. And I certainly, if lawyers have concerns or issues or good ideas about what we could change in the rules to accommodate this, I'd like to hear about them. Please feel free to email me and let me know. There's a lawyer in Nashville that I got several ideas from, who actually connected over Twitter and said, these are some good ideas. And I sent, at least one or two of those onto the Rules Commission to be considered.
Oh, wow.
And so I welcome that, because, I'm not in the trenches anymore. I don't really always get the what those needs are. So I really welcome that information.
All right. We had a question sent in asking if the current ban on in-person hearings and jury trials includes a ban on in-person and party depositions. And I think I know that first of all, it's not really a ban on in-person proceedings.
Right.
It restricts them, but
it doesn't affect depositions. It would not affect depositions. You can have depositions. I think depositions have been, a lot of lawyers have suspended depositions just for safety reasons, but there's nothing that the court did to restrict depositions. And I think, as long as you do the social distancing, try to wear a mask as needed, and just do all the safety precautions, you can continue with that.
Justice Lee, you mentioned and we have a few questions in the question box, but I was getting ready to ask you, you had talked earlier about the bar exam, and I know you and I spoke earlier this week about the stories out of Utah, and then I saw this morning that California has in the ABA email this morning, they said that California has postponed their bar exam and moved the bar exam online. We have a question from Professor Hemingway at the law school, and she says, thank you and the court for all you're doing for the bar. We appreciate all of you. And she said the second bar exam date also is appreciated. Many thanks for addressing the concerns and needs of our law students, many of whom are in difficult circumstances and currently quarantined out of state. Some states are considering or have adopted diploma privileges and other non-exam means of qualifying law school graduates for bar membership as a result of this crisis. And I think that Utah is one of the states that's considered that. Can you offer any comments on additional measures or alternatives that the court may have considered or is currently considering relating to bar admission, especially in light of the potential for changed social and viral circumstances after the bar exam filing deadline?
We have not considered waiving the bar exam. I looked to see what Utah was proposing, and that their proposal is out for public comment. The court has not acted on it, but their proposal the headline reads, let law grads skip the bar exam. That sounds really, really pretty cool, but actually if you read the fine print, you had to have graduated at a certain time. You have to attend an ABA accredited law school that posted a first-time bar passage rate on last July's exam of 86th percentile or higher. So it's not any law school. So if we, for example, took Utah's proposal, that would only apply to Vanderbilt and Belmont. I have a problem with that.
All right.
I don't think we just let it is 80 percentile or higher. Like, where'd that number come from? I don't know. But it's not for everybody. It's really for a select few who attended a certain law school. I don't think we're very confident that we're going to be able to get the July exam safely. And then we've also got the overflow into the September exam. So unless things take a really bad turn that we're not anticipating, we feel very confident we can give the July and the September bar exam. We've also amended the rule to allow the student, if you graduate this year and you signed up to take the bar, we extended that student practice through, I think it's 2021. So if you're graduating this year, you're going to be given the opportunity to practice under attorney supervision for much longer, like maybe additional year than what you could have otherwise. So we have done that to help students. There's not a great solution. It's just a hard time for everybody. If we don't feel like we can give the bar exam safely, we're going to do something else. but we feel pretty good about what we've got planned right now, and we just hope for the best and hope things continue to, the conditions improve.
All right. And we've got a few other questions here, and Justice Lee, we're scheduled to go until 1 o'clock here, but I'll stay as long as you're comfortable staying, and we are recording this, and so if you need to leave, let me know, and we can find a way to answer these questions outside of this forum and publish them to our members. Someone asked earlier, how can the governor alter a state statute regarding witnessing of wills through an executive order? What if years from now the executive order is challenged and deemed void or ineffective and the will is void?
I need to talk to a lawyer about that. consult a lawyer. I don't know. I know in a state of emergency, the governor has a lot of powers. I've not asked that particular question. I know people have struggled to get wills notarized and signed and all that. And this in particular is a time when people maybe need wills. So I think the governor has a lot of power to do a lot of things, but that issue might actually come before the court, so I probably shouldn't give an advisory, and that will probably be wrong anyway, so I'll take a pass on that one.
All right. Justice Lee, Cheryl Rice asks 3 questions, and I think you have touched on most of this, but we'll go through. What changes do you see to operation of courts that may carry through after the current pandemic subsides? We've talked about that. We've talked about electronic filing. She wanted to know if you saw this as increasing the opportunity for the courts to move to electronic filing statewide.
Absolutely.
And then she asked about the scheduling orders, and you touched on that earlier. She said that it appeared that the initial order applied to extend dates set by scheduling orders, but the late March order, you mentioned, exempted scheduling orders from that exception. And she asks if that's a correct assessment of the 2 orders, and if so, what was the court's thought process there, and what about dates that fell between the 2 orders?
I think we intended to extend deadlines because we were worried that statute of limitations was running and people would be in trouble on these deadlines and couldn't get to the courthouse to file things. I don't know that we just thought all deadlines would be extended, and I don't think we actually considered deadlines and pretrial orders. That issue was raised, and then we said, you know, trial judges have set those deadlines. And there's particular reasons they set those deadlines, so we need to leave that to the trial judges to decide. So we really just clarified that we didn't intend to mess with pretrial orders. That's up to the individual judges. So I don't think we ever intended to change the pretrial order deadlines. So if you fall in the gap, I guess you're still stuck with the pretrial order deadline. But I think judges are going to be your trial judges are going to be pretty understanding of this confusion, because honestly, when I realized that it was brought to my attention there was an error on the website, our 10courts.gov website about pretrial orders. It wasn't clarified, and I asked that it be changed. It didn't happen. I thought it happened. It didn't happen. So we ended up getting it fixed. But there's really solid basis there for lawyers to be confused about that. And so I think that would certainly, there's a good basis to give people slack on that issue. But if a judge has set something in a pretrial order, you need to comply with it until he or she changes that order. But that's a good question.
An anonymous questioner asks if you can tell us what is in the proposed plan that was submitted by the 6th Judicial District.
I've not seen that plan. I'm sure it's going to be outstanding in every way. I've not seen it. Okay. I suspect it's going to have encourage staggered. From the other plans I've read, they're going to encourage face masks. They're going to encourage disinfectants. They're going to encourage staggered hearing times, which I think is a good idea anyway, frankly. I've always was sort of bothered as a lawyer to show up at 9 o'clock, with 100 other people and late hours. Why couldn't I come at 10 and, get worked in? Staggered hearing times, limit the number of people in the courtroom. I think that's what I'm seeing in these other plans.
Right. So, and I was curious about how the process has gone in terms of the plans being submitted and approved. You said you haven't seen the 6th Judicial District plan. Is that just something that Chief Justice Bivens is handling, or is he asking for the rest of the court's input? How does that process work?
We discussed it on the front end, and he suggested either his office, he and his staff approve, or the whole court approves. And I particularly felt strongly that his office should approve, because the time you get 5 people weighing in on a plan and approving it, I mean, this thing, they may have a vaccine by then, you know? So it's like, we don't need to drag this out. Let's just, but if he had any questions or concerns, then he would throw it to the court. But so far he's not. I noticed there's a couple of, he does send us the plans once they're approved.
Okay.
But there's been a couple that have been sent back with modifications requiring changes. So there is quite a bit of oversight going on with these. And I think I think the turnaround's been fairly quick, and they intended for it to be a quick turnaround. So that's why I'm thinking if the 6th district was submitted Wednesday, I'm hoping that gets back out today or Monday at the latest.
Okay, great. You mentioned earlier when you were summarizing the orders, you talked about the provisions that were an effort to reduce jail population during this. And that I remember that was in the March 25th order, and it's not included in the most recent order. One of our members has asked what led to the court's foresight in requiring judicial districts to submit plans to reduce jail population in response to the pandemic. And I know we had a comment earlier in the chat box about how there is a problem in Shelby County with inmates there. So can you tell us a little more about the efforts to reduce the jail population?
We just felt very strongly going into this that jail population, that the jails were a petri dish for an explosion of COVID-19. I mean, you just can't pack people in those enclosed spaces. And they're not going to get it in there, but a guard's going to get it at home and come in and then expose the whole group. And it just could be a really bad situation. So we just were concerned about that on the front end and felt like we needed to reduce the populations. It's not something we could do, but we needed all the trial judges to work together with the DAs and make that happen. And they did. They did a great job of it. And we dodged that bullet, I think. And we've avoided any serious problems so far in our jails. It could pop up tomorrow, today, whatever, but so far we've done well. And unlike the state prisons, which we have no control over with that. That worked out well, I think.
Good. We have another question. This is pretty specific. If we serve a pleading by email, are we required to send a fax stating, quote, this was emailed? I assume that rule is suspended, the questioner asked.
I don't know about that. I would think so. I mean, no, I don't know. I'd have to go back and read that rule more carefully. I've not had that question asked to me, but we did suspend all court rules that would limit use of electronics or limit, getting this stuff done.
Right.
Without studying that rule, I can't say for sure that was done. I mean, a lot of new lawyers, you say fax, and they're like, what? Fax is such a throwback. I don't know why we're still even using faxes.
I think lawyers are some of the last people in the world still using fax machines.
Yeah, well, judges use them too, so.
All right.
Oh, let me mention one thing, and you may going to get to this, but before I forget, we were to have a swearing-in ceremonies the first week in June, and we've decided to do those by Zoom. So if you know anyone who passed the February bar, wants to be sworn in, contact my office, my assistant, me, whatever, and we'll get you set up to be sworn in through Zoom. Each justice is going to take a certain number of people. We're not all going to get together and do that. We're going to do it electronically. The reason and let me say this, we're going to do it, I think we've talked about Hanson doing it Wednesday, June 3rd in the afternoon with me here in Knoxville. Of course, we can do it for anybody in the state, but you might say, why don't they just do it like if they're all ready to go tomorrow, whatever, in May, get these people to work? Well, the reason is, we learned this the hard way a few years ago, because I was all fired up to do the swearing-ins in May, and why are we waiting until June? These people need to get to work. Well, if you're licensed as of June 1, you owe the professional privilege tax for the whole year. So it's like, you're sworn in, now give us a check. So if you wait till June 2nd or after, you don't owe the tax as of June 1, and you get that whole year without paying your professional privilege tax. So if somebody really needs to get sworn in before June 1, we can do that. I'm happy to do that, but they just need to know they're going to owe that tax that nobody likes to pay.
That's an important thing to keep in mind.
Yeah. So that's why we're looking at probably June 3rd. So we're happy to do that. And you can have family members on your Zoom call, you know, the lawyer, family member, your KBA sponsor.
All right.
It'll be kind of fun, I think. It's going to be a different approach, but I think it's going to be kind of cool.
I'm looking forward to it. All of this is new to me, so it'll be new to everyone else as well. We have a few more questions in the chat box. Don Vowell says, everyone likes the idea of extending the statute of limitations, but do you think that anybody will argue that since statutes of limitation were created by the legislature, only the legislature can change them?
Well, we did think about that, but we have declared a state of emergency, and I assume that we will rule on that issue as to whether we had the authority, and I think we believe we did. So I think you're pretty safe, assuming that statute of limitations was extended.
Rick Powers has asked, while of course we have to go day by day depending on the circumstances and the information that the court receives, he would like to know, when might we expect a further order for plans beyond May 31st? In planning for the late summer and fall, do you think we are safe in presuming we will be back to jury trials by then?
I think we'll be back unless something goes wrong. I think we're hoping to be back after July 3rd. But I think we're going to have to wait till July 3rd and see what's happening on the ground. But that's our hope. And I think the advantage of having judicial districts make their own plans is, you know, if Knox County continues on a downward course of COVID-19 cases, then they can ease up on their restrictions. They can just play it by ear. So by September, maybe the 6th district will have a totally different plan than what they've submitted to be approved. It's just hard to say. I mean, some of the experts say, you know, this is going to go away. We've got some good treatment. Others say this thing's going to come back in the fall. So it's just really very, very uncertain. I wish I knew how it was going to turn out. But I think if you've got a jury trial set in the fall, you can count on it happening. I mean, as of right now, unless the situation changes.
Okay. And then obviously the schedule for the orders has seemed to be in the week leading up to the expiration of the previous orders. It's usually then, because you can't plan too far ahead for these things, right?
You really can't. That first order we did was kind of sudden. We did it on that Friday and went into effect on Monday. It kind of caught some people off guard, but we really had to do it. And Tennessee was really at the forefront of suspending in-person hearings, and we did that to protect everybody in the system. I think it was the right thing to do. I was reading yesterday, there's a couple of trial court judges in New York City who have died from being exposed to the virus. And they, even though they had a big problem in New York City, they were continuing with packed courtrooms and up through March. And it took a real toll on the lawyers and judges. So I'm really proud of the way we responded. And I think we really protected the bench and the bar and the parties by taking these really extreme measures that I never thought we would ever have to take.
We had a question that was submitted about whether, I'm trying to find it here, but it was about expanding the services that can be provided by non-lawyers in a situation like this. And Mr. Stanuzik has submitted a question in the Q&A asking if the Supreme Court has discussed whether to allow unlicensed law school graduates who may now practice until 2021 under the supervision of an attorney the ability to take court appointments and submit bills to the AOC.
We have discussed that and decided that not to allow that at this time, because that would require a drastic change in Rule 13, and it just creates a lot of difficulty. So lawyers now, we've extended it to 2021, so they have the opportunity to practice under attorney supervision. But in terms of being able to get on the AOC website and bill for that service, it needs to be a licensed attorney.
Okay.
I know this has hit indigent. I know this has hit lawyers who do indigent work very hard, and there's not a great solution there. We've tried to come up with some things, but it's a problem.
And we're going to try to wrap things up shortly,
Okay.
Justice Lee. We appreciate your time, but we had one more question about the plan that was submitted. What is the general timeline for implementing a plan for a judicial district once it is approved? For instance, if something is approved today for the 6th Judicial District, does court start back Monday or in a week or what?
I think it depends on what that plan says, but I think it's going to be pretty fast. I think it depends on what the plan says, but I think once it's approved, it's in effect generally. So.
All right. Justice Lee, you may know that the KBA has a program going right now called Finding the Silver Lining. We're asking attorneys and members of the KBA to send in things that they've learned that are good things about what the pandemic has done to change our lives. And we're doing that up through social media. I was wondering if you had any silver linings that you could think of, things that have ways that you've seen the good in people through this pandemic.
Yeah, I have. I think people have slowed down. They've had more time. They've probably seen a lot of shows on Netflix. I think it's really caused us to just stop and take stock of where we are, to have more time to think, to really appreciate the opportunities that we have. I think when things open up, we're going to be really excited to go back out and do things with people. I think it's caused us to think of new ways of doing things, like through electronic medium, that I think will result in greater efficiencies in the system going forward. So there's a lot of bad things going on, but I do think there are some silver linings in terms of just what it's done for us personally, and then that we've been forced to think outside the box and try new ways of doing things. So the lining is thin, but I think it's there. I think it is a silver lining.
Well, Justice Lee, thank you so much for your time this afternoon. Rick Powers posted a comment in the box saying, "We are very appreciative to you and the other justices for your insight and your being mindful of the needs of the practicing bar. Your comments today quite readily show that you remember what it was like before you assumed the bench." So on behalf of the KBA, thank you so much for being here this afternoon. I'd like to tell our attendees that if you have any questions that we didn't see for whatever reason today, please email them to me or to Marshall Watson. We will relay those to Justice Lee and see if we can get an answer to you. Again, this is being recorded and you can watch it for free later. Justice Lee, I also would like for you to extend a thank you to the entire court from the Knoxville Bar Association and Chief Justice Bivens. We do appreciate all the work that you've done on behalf of the bar and on behalf of the citizens of the state of Tennessee.
Very well, thank you. It's our pleasure. It's our honor. I hope we've done the right thing. We've tried very hard to make good decisions. We're in uncharted territory, so it's really tough to know. One thing, I will remind you, if you have questions about these orders, are all on the 10courts.gov website. If you feel like things are really going bad in a case or a court that is contrary to the orders, you can call the AOC and talk to the general counsel. I know we had a situation in West Tennessee where early on a couple of judges were ignoring the suspension of in-person hearings and we're having packed courtrooms. Fortunately, someone called and said, hey, this is what's going on here. And the call got made and that got taken care of. So we really want to know if there are problems and people do not feel that they feel like their safety has been jeopardized by anything. So reach out if you're having problems with things. And again, some of the best ideas I've been able to convey came directly from lawyers. So let us know what's on your mind.
All right. And then I have a few announcements just for the KBA. Remember that we are rescheduling the Law Day Luncheon for August 19th, which is the day after the 100th anniversary of Tennessee becoming the 36th state to ratify the 19th Amendment. So please be sure to register for that. Next week, we have an estate planning CLE Zoom webinar on May 5th. And then we're also having a Take Care Tuesday virtual social hour on Tuesday, which is, as you may know, Cinco de Mayo. It will be 5 p.m. on the 5th day of the 5th month. And I plan to be there, so please join us for that. All these events and more are on the calendar at knoxbar.org, and you can register through that website. And Marcia has also asked me to see if anyone who is still listening is willing to send in pictures of themselves in seersucker in honor of Law Day. So you can send those to the Knox Bar. You can send them to Marcia or me by email. You can submit it by Facebook or Instagram or what have you. So with that, I just want to thank you once again, Justice Lee, and I look forward to seeing you in person soon, hopefully, and happy Law Day.
Happy Law Day to everybody. Thank you all for participating. Hope you got something out of it.